Serial number 35, Union of India versus Srimati Rameshwari Devi. For the petitioners, Sri Radhika Raman.
My lords had asked me whether the juniors of the deceased employee were regularized or not. So I tried to contact the concerned department, but contact could not mature, my lords. So I will have to file an affidavit with this effect.
What do you have to say about para 19 of the order?
Para 19?
Of the order.
Hmm? No, उतना फाइल लाती है. Para 19 at page 32, my lords. It is not the case of respondent that the applicant's husband did not fulfill the requisite qualifications for regularization against Group D post, as the respondents have given no reason for his non-regularization. I am inclined to hold that there was no consideration of his case. The DOPT OM dated 10th September 1993, which governed his service matters, provides for regularization of temporary status casuals through filling up Group D vacancies. Though no time limit has been set in the OM Supra for consideration of a TS casual for appointment against Group D vacancies, it cannot be shelved beyond reasonable limits. In the instant case, the applicant's husband served continuously as temporary status casual for almost 22 years, and yet he was not regularized for reasons best known to the concerned authorities, denying the applicant the benefits of family pension and other come retirement benefits to the applicant, to which she would have become entitled had her husband been regularized, but was not regularized despite the statutory provisions, and fulfilling the requisite conditions appears grossly unjust. Thus, the balance of convenience seems to lie in favor of the applicant.
What is your answer to this observation of the learned tribunal?
अब my lords, Annexure 1 at page 16, my lords, that is OM dated 10th September 1993, my lords, that grant of temporary status and regularization of casual workers, formulation of a scheme in pursuance of the CAT Principal Bench, New Delhi, judgment dated 16th February 1990 in the case of Rajkumar and others versus Union of India. I may be permitted to read out page 17, my lords, which is page 17. Ministry of Personnel, Public Grievances and Pension, Department of Personnel and Training Casual Laborers, Grant of Temporary Status and Regularization Scheme. My lords, temporary status is in clause 4, my lords. Temporary status would be conferred on all casual laborers who are in employment on the date of issue of this OM and who have rendered a continuous service of at least 1 year, which means that they must have been engaged for a period of at least 240 days, 206 days in case of offices observing 5 days a week. Such conferment of temporary status would be without reference to the creation availability of regular Group D posts. Conferment of temporary status on a casual laborer would not involve any change in his duties and responsibilities. The engagement will be on daily rates of pay on need basis. He may be deployed anywhere within the recruitment unit territorial circle on the basis of availability of work.
It speaks
Such,
about the entry as a casual labor. What
my,
about the person who was working continuously for 22 years? It is about the entry.
my lords, he was not regularized in view of this
That's why you
OM,
were
my
asked
lords.
to
Page,
take.
page 17, clause 4.4. Read.
4.4. Such casual laborers who acquire temporary status will not, however, be brought on to the permanent establishment unless they are selected through regular selection process for Group D posts.
Where is this exercise has been undertaken by the department from 2002 to 2012? Have you undertaken such exercise between 2002 to 2012 so as to say that the deceased employee is not entitled to?
My lords, I have some hearing problem, my lords, so I am.
Then take assistance.
That we have acknowledged.
Take assistance.
hearing problem हो रहा है हमको.
Tell him what is the requirement of the court.
क्या बोल रहा है? क्या बोल रहा है?
I beg your pardon, Your Lordship.
Sir, in terms of page 17, kindly show it to him. Clause 4.4.
Class 4, okay.
Read, Mr. Counsel.
Class 4.
What do you think?
4.4. Such casual
Such
laborers
casual laborers who acquire temporary status will not, however, be brought on to the permanent establishment unless they are selected through regular selections process for Group D posts.
correct. Where is the such exercise undertaken by the department from 2002 to 2012?
इसके लिए एक्सरसाइज नहीं किया है. अच्छा नहीं.
Please take them. Heard the matter for some time.
Para 4,
Uh,
my lords.
Core issue involved in the present petition is whether deceased employee is entitled to retirement benefits, regularization, and retirement benefits to his LRs or not. To stop. Undisputed facts are that deceased employee was appointed in the year 1997 with a temporary status within bracket Group D. It was abruptly cancelled on 26th with effect from 26/3/1998, and it was subject matter of litigation before the tribunal in OA number 149 of 1998. Twist of the tribunal was pleased to allow the tribunal allowed the OA number 149 of 1998. In the result, deceased employee is entitled to restoration of his position to stuff. Thereafter, respondents issued an order on 14/6/2002 and deceased employee reported for duty on 15/6/2002 with a status of temporary status. While working as such, he died on 13/2/2019. In this backdrop, wife of the deceased employee filed an application before the tribunal seeking certain benefits. The OA was allowed, hence the petition is by the department to stop. The petitioners have not apprised this court as to why the deceased employee's services have not been regularized during the intervening period from 2002 to from 15/6/2002 to 13/2/2019, the date on which deceased employee died. To stop. The petitioner department have a policy decision dated 10th September 1993. It is in relation to grant of temporary status and regularization of casual workers. Such a scheme was introduced pursuant to the orders of the CAT, Principal Bench, New Delhi, dated 16/2/1990, in the case of Raj Kamal and others versus Union of India. To stop. Appendix to the aforesaid communication, certain criteria have been laid down for the purpose of temporary status followed by a regularization. To stop. The aforesaid policy is in vogue since 10 September 1993. To stop. Therefore, petitioners have not apprised this court as to whether the scheme was invoked in respect of deceased employee during the intervening period from 15/6/2002 to 13/2/2019 or not. To stop. Obviously, no orders have been passed in regularizing the services of the deceased employee. To stop. That apart, no reasons are forthcoming as to why the deceased employee's services have not been regularized during the intervening period cited supra. To stop. Therefore, competent authority dash petitioner is hereby directed to file a detailed affidavit as to whether during the period from 15/6/2002 to 13/2/2019, 93 scheme has been implemented in regularizing temporary status persons. To stop. Further, have they prepared any seniority list of a temporary status so as to go on regularizing depending upon the number of vacancies available during the period from 2002 to 2019? All these detailed information shall be made available on the next date of hearing, failing which the petitioners are liable to pay cost of rupees 15,000. Cost shall be paid to the respondent. List this matter after 4 weeks. It is made clear that no further time would be granted.